Welcome once again to Lehto's Law. Here's Steve Lehto.
A few people sent me this story about a judge in Michigan getting ripped on by the Court of Appeals. And it's a funny story, and actually the story in the news doesn't quite do it justice because they missed, or I don't think they emphasized one of the nuances of the story enough, so I'll talk to you about it. Ed White wrote the story for the Associated Press. Court knocks judge, suggests he's in wrong line of work. A wrong line of work. And a judge in Michigan who's known for his own ripping into criminal defendants is catching criticism again from a higher court. And again, yes, it's happened before. It's happened before on this case. The Michigan Court of Appeals suggested that a Jackson County judge is ripe for a misconduct investigation for how he's handling the sentencing of a woman who was convicted of killing her boyfriend back in 2015. The court overturned a 30-year minimum prison sentence that he'd given her and said a different judge must handle the case because this is the second time on this case that the Court of Appeals has had to say, no, you did it wrong. And now they're sending it back down for another judge to straighten out. So the first sentence was a minimum of 35 years, and the court said, dude, you did that completely wrong. There's guidelines, and he didn't explain why he went out of the guidelines, and he appears to have done it wrong. They sent it back down, and he did it wrong a second time. And the record on this makes it very clear that he's doing this wrong. So the appeals court wrote in a unanimous opinion, if a trial judge is unable to follow the law as determined by a higher appellate court, the trial judge is in the wrong line of work. And you have to understand that the courts try to do what they do with a certain level of dignity. So they're not going to come right out and go, dude, you're an idiot. But that's what that sentence translates to, okay? If a trial judge is unable to follow the law as determined by a higher appellate court, they're basically saying, you listen to us. The trial judge is in the wrong line of work. You shouldn't be a judge. The woman at the center of this claimed self-defense, but was still convicted of second-degree murder in the case. So she claimed it was self-defense, jury didn't buy it, and they convicted her of second-degree murder. The appeals court, however, said that the judge treated her as if she were convicted of premeditated first-degree murder, which is a little different of a thing. The court noted that the judge grilled her and interrupted her right to speak, and you probably have seen this before, where during a trial, a defendant has the right to not speak, Fifth Amendment. They can just sit there like a bump on a log and not do anything during the trial other than talk to their attorney quietly. However, at sentencing, a court will often look at the defendant and say, would you like to say anything? And here's the thing, you don't have to. So it's not a violation of your Fifth Amendment rights. But your speaking to the court is also not considered testimony. So you are allowed to speak to the court and say something such as, I'm sorry for what happened, or I'm sorry this happened, or I'm sorry I did it. You can say anything you want. And a lot of people will express remorse at that point in time and say, look, I'm sorry. I wish it hadn't happened. I wish I hadn't done this. I made a mistake, whatever it is. And that idea that you speak after the trial, but before you're sentenced, is something that's considered to be a right you have. And so the appellate court, in their opinion, actually showed the transcript where the judge asked her if she would like to say something. She started talking, and he cut her off and started arguing with her about it. And that's not what's supposed to happen there. She's not testifying at that moment in time. She's merely making a statement. The judge should let her talk. So he interrupted her and grilled her, and then the judge said, she stabbed the victim in the heart not once but twice and murdered him in cold blood. She planned it. And that's what he said during that exchange. So the judge's conduct may even warrant investigation by the Judicial Tenure Commission, the judges wrote in their opinion. So they actually said, not only are we sending it back down, not only is another trial court going to handle the sentencing, but this might be a matter where the Judicial Tenure Commission needs to look at the behavior of this judge and see if it's appropriate for a judge. The news people did contact the judge's office on Wednesday, but they had no comment. So one of the appellate court judges said that she had read the transcript from the hearing referring to the defendant speaking. and found it hideous what the judge had done. The judge is known for making sharp remarks. Courtroom excerpts on YouTube have been watched hundreds of thousands of times. In 2015, while sentencing a man who had broken into a police officer's home, the judge said he wished the owner had returned in time because you know what? You might not be going to the Department of Corrections for 10 years. You might be getting buried in some cemetery. He said that. Apparently one of his more popular things that he said. And on another occasion, he took off his robe and helped police restrain a defiant man in his courtroom. Now, you might say, Steve, what's wrong with that? Guy's out of control in the courtroom. The bailiffs are having a hard time with him. The judge takes off his robe and jumps over the bench and helps wrestle a guy to the ground. Do you think that judge can remain impartial and unbiased going forward in that case with that person? So what the judge needs to do is either sit on the bench and let the bailiffs do their work or get up and walk out of the courtroom. And that's the right thing to do, so when you come back in later, people can't say, oh, you're ruling against this guy because he got unruly in the court. You know? So I went and pulled the actual opinion that was filed by the Court of Appeals to see what other language might be in there that's fun. And it was there that I noticed the nuance that this was in front of the Court of Appeals twice, and both times they said the lower court screwed it up. So in the beginning of the case, it says the defendant appeals of right her sentence for second-degree murder. The case returns to this court following our decision vacating the first sentence, and we order resentencing then. We again vacate and remand for resentencing before a different judge. So they're saying, look, we gave this guy 2 tries. We're not giving him a third. They also point out the Michigan Code of Judicial Conduct, Canon 3A12, states that a judge should avoid interruptions of counsel in their arguments except to clarify their positions, and should not be tempted to the unnecessary display of learning or a premature judgment. The same principle applies to a defendant's allocution, and the allocution is the technical term for when the defendant addresses the court before sentencing. So she started to speak, and the judge cut her off and started lecturing her. Defendant declined to speak further, following the trial court's dismissive response to her attorney's objection to the trial court grilling the defendant instead of listening to her. And that's what happened. She started to speak, and the judge cut her off and started firing questions at her. Her attorney said, Your Honor, I've got to object to this. And then the judge berated the attorney. And at that point, she's like, never mind, I'm done. And it's very, very clear that she stopped talking because she thought, why bother? So under the circumstances, that can hardly be construed as an expression of satisfaction. It is far more likely to have been the result of intimidation in light of the fact that the trial court had abandoned its role as an impartial magistrate and instead usurped the role of prosecutor. And keep in mind that in the courtroom, there's a defendant over here and a prosecutor over here. These are adversarial people, or parties. And in the middle is the judge who's supposed to be neutral. So, defendant would reasonably have wished to avoid incurring even further displeasure from the trial court, especially when the court has already shown its inability to follow the sentencing guidelines. Under the circumstances, it is clear defendant was offered only an illusory and superficial opportunity for allocution. The distinction between a conversation and an argument may not always be clear, but the trial court plainly violated defendant's rights here. The trial court's abandonment of impartiality and unwillingness to follow the law would be bad enough, but the trial court also went so far as to state on the record, and this is the funny part, is you got to be careful what you say when you're a judge. I've said this before. Everything you say is on the record. So when this case got sent up a second time, the Court of Appeals got to see what the judge said at the sentencing. And the judge said, and this is the quote, and they want another judge to do it again, and maybe they can convince some judge that, oh, I should only get 12 years for a second-degree murder when I stabbed somebody in the heart twice. So he's referencing the fact that the Court of Appeals might ask someone else to do this, and so they wrote, this statement further reflects the inability of the trial court to conform its rulings to the law, and the appearance of justice can only be preserved by reassigning this case on remand. It's going to a different judge. So when he's mocking the Court of Appeals, saying, oh, they want a different judge to do this, guess what? They do. Furthermore, the trial court's conduct and statements may warrant investigation by the Judicial Tenure Commission. So in this little, it's not an out-and-out catfight. But you have the Court of Appeals the first time sending it down saying, got to follow the guidelines. At the second hearing, he actually jokes they want it done again, and then he does the bad thing again. It goes up and the Court of Appeals goes, you know something, you're in the wrong line of work, my friend. And by the way, you might need to be looked at by the Judicial Tenure Commission. Furthermore, the trial court's conduct and statements may warrant investigation by the Judicial Tenure Commission. They then wrote defendant's sentence is vacated and this matter is remanded for resentencing before a different judge. So that judge just got smacked down by the Court of Appeals, and they'd reversed him previously on the exact same case. And now this is one of those things that a lot of people are going to go, well, Steve, you know something, she did kill somebody. She deserves to go to prison. Yeah, she does. She does. And we've got laws. And our laws and the rules that we try to follow as a society are there for a reason. And one of them is that we know their laws and rules apply to us, so we conform our behavior. And we know that if something that we do gets us in trouble, we're going to have to be held accountable. And so there are rules and laws on how you'll be sentenced for a crime. And so if you do something where you break the law, here's what you face. It's not, oh, you break the law and you could just get anything, whatever the judge feels like. And so there's sentencing guidelines. They're there for a reason. So he sentenced her once to 35 years, which is beyond the guidelines. And then when told that was wrong, he goes, okay, 30 years, which is also beyond the guidelines. And on the record, by the way, you can stray from the guidelines. But to do it, it's very, very clear that you've got to lay out why you're doing it, and you put in good reasons as to why you're doing it. And then if it goes up on appeal, the Court of Appeals will look at it and go, well, they deviated from the guidelines, but did they deviate for a good reason or not? An allowable reason would be nice. And so twice the Court of Appeals looked at it and said, no, the guy did it wrong. And clearly he did it wrong. So now we're going to send it back after the second time and let someone else do it. Because otherwise he's going to look at it and go, okay, 29 years, 28 years. And of course he might yell at the defendant some more when she's trying to explain herself or trying to apologize. So it's a weird case. Not often do you see the courts going this far. And I know you're going to say, Steve, this far. Yeah, social media fights can often escalate well beyond this. But trust me, in the court system, this is pretty bad because they've actually said he's in the wrong line of work and he's screwed this up twice. We're going to let someone else straighten it out. And maybe the Judicial Tenure Commission ought to take a look at this guy. So, you know, if he gets a lot of hits on YouTube, I guess that's something. Maybe he can monetize his channel and make some money. I don't know. But the point is that a judge has a job to do and laws to follow. And I've mentioned before that Michigan judges are elected. And so whether or not this affects him in his next re-election campaign, who knows? A lot of people aren't even aware of who the judges are in their districts or circuits. But this is a pretty good slapdown. So Ed White wrote that for the Associated Press. Mark, Brandon, Frank, Danny, and Raymond, the attorney, sent it to me. Court Knox judge suggests he's in the wrong line of work. And I think he is. Questions or comments, put them below. Let's talk to you later. Bye-bye.
Thank you for watching Lehto's Law.
Loyalty is for sports teams and relationships. Loyalty to vehicles? Not so much.